Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw an eye and to give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
It's going to make a noise with you as I set it up. All right.
Good morning and welcome to the second day of the first set of arguments in our new term. For those of you who are either new to the court as advocates or it's been a long time, the court affords calendar cases 30 minutes apiece aside, and the first 5 minutes of which are given to you free of interruption by the court. I encourage you to use those uninterrupted moments to get to the outcome determinative issues in the case, and I assure you we have read the record or read the file and your briefs, and I wouldn't spend a moment, unless it's critical to your argument, going over background. So with that, we'll call the first case, Lego versus Liss.
Thank you, Mr. Chief Justice, and may it please the court. Assistant Attorney General Joe Freilich, appearing on behalf of Trooper Liss. Also present is Deputy Solicitor General Eric Rastusha. And I understand I have to keep my own time, but I'd like to reserve 5 minutes.
Yes, you do.
Thank you, Your Honor. The statute that's at issue in this case, MCL 600.2966, is Michigan's friendly fire statute. The situation that gives rise to this case is exactly what the legislature had in mind when they passed the statute. This statute is a recognition that police officers and firefighters have a dangerous job to do. And it's a recognition that because of the dangers of their profession and the intense pressures and high-stakes situations that they find themselves in, and situations that call for split-second decisions about life and death, it's a recognition that in these circumstances there's a greater risk that police officers and firefighters could harm each other that just isn't present in other professions. Because the very nature of these professions is to confront danger. And as it relates to police officers, this generally manifests itself in 2 ways. First of all, in the operation of motor vehicles. Police officers are called upon to pursue those who break the law, and often they do it in motor vehicles in high-risk driving situations, and in situations where there's a greater risk to harm other police officers as passengers or other police officers otherwise involved in these chases. And the other way it manifests is the situation that gives rise to this case, that we ask police officers to do something that no one else does, to carry firearms and to use these firearms to apprehend those who break the law through the application of deadly force. And inherent in carrying out that duty is a risk that one police officer could harm another police officer, especially under circumstances where the stakes are the highest, the pressure is the most intense, and split-second decisions are being made about life and death. It's just a reality of the job. It's normal, inherent, and foreseeable that in the highest stakes situation, a mistake could be made and that an outcome could be severe. And this statute recognizes that, and it recognizes that police officers suing other police officers for injuries that arise out of these inherent risks is a bad policy, because police officers have enough to worry about when they're doing these things under intense pressure and high stakes, that they shouldn't have to be concerned with civil liability if they make a mistake when the stakes are the highest. And that's what the statute recognizes. It recognizes that it's a different situation when one police officer harms another. And that's why there's 2 statutes, 2966 and 2967. And that's why 2966 is a broader grant of immunity than what the public is given when a police officer is injured from a risk that's inherent in the profession. Because what the statute is really doing is providing immunity where the Governmental Tort Liability Act doesn't. The Governmental Tort Liability Act, as it pertains to negligence, gives an officer immunity if they're acting in the course of their employment, for an agency exercising the discharge of a governmental function, and if they're not grossly negligent and they're not the proximate cause of the plaintiff's injury. This statute recognizes that when the stakes are the highest and a mistake is made, that a police officer could be grossly negligent and that he could be the proximate cause of another officer's injury but as a matter of good policy, he should still get governmental immunity. And that's why this case is the paradigm case under the statute. Detective Lego and Trooper Liss were confronted with the most intense, high-stakes situation thinkable, the application of deadly force to an engaged and armed felon. And in that moment, they had to make a split-second life-and-death decision about the application of deadly force. And inherent in that was a risk that one officer could shoot another. And that risk is inherent whether Trooper Liss was negligent or grossly negligent, because when the stakes are the highest and a mistake is made, the outcomes are severe. And that's what happened here. And that's why Trooper Liss may have been grossly negligent, and he may have been the proximate cause, but he should still get governmental immunity, and that's what the statute's about. And the fact that he might have violated policy only demonstrates the inherent nature of this risk. The fact that we have policies regarding the use of force in this manner demonstrates that there's an inherent risk that one officer could harm another. Trooper Liss should be entitled to governmental immunity in this case under the statute. This is the paradigm case. This is the friendly fire statute. I'd be happy to answer any questions you might have.
Thank you. Counsel?
Well, actually, can I ask a question? I was waiting.
Oh,
Can I ask some questions?
you have to do it quicker.
Oh, I'm sorry, Chief. I was just giving deference to other
More
panelists.
senior justices.
Yeah.
Yeah, all right.
Just being polite.
Yeah. But seeing that there were no other questions, if it's okay. Counsel, first off, good morning and welcome to the court. If I could just walk through with you a few things, if that would be okay, because I just want to get a better understanding and appreciation. Let's talk about the training situation here. Now, the Officer Lego and Trooper Liss, this was a special task force, correct? They were part of?
Yes, Your Honor. They were part of a large, it's alleged in the complaint that they were part of a larger task force, but that they were members of separate task forces within that larger umbrella.
And now, the level of training that is required to be in this task force would be, they were obviously selected to be in this task force because their training and their abilities were at a heightened level. Is that correct?
I'd agree with that, Your Honor.
Okay, so this is kind of an elite task force that these officers were a part of, right?
I'd agree with that, yes.
Okay. And the question I would have then is, going to the actual incident, just help me to understand this. And again, I just have a lot of admiration for law enforcement officials because of the things that they face, and I understand there's a lot of adrenaline and excitement and things that are happening that are going to be taking place. But let's just talk about the protocols and procedures if we could. So is it not in fact the case that when Trooper Liss came, the officers on the task force were already in formation? Is that correct?
That's what's alleged in the complaint, Your Honor.
Okay. And is it not in fact the case that when they approach that formation, protocol would dictate that that Officer Liss should have remained in his vehicle? Is that in dispute?
I don't think that's in dispute. I'd be willing to agree with that for purposes of argument.
Okay. And upon getting out of his vehicle, he joined the formation that had already been established, correct?
That's what's alleged in the complaint, yes.
Okay. And the reason I was going through this is because, it's leading up to the question I'm just trying to get your sense of, and upon joining the formation, he had his weapon. He did not, he basically didn't use the weapon in the way that he was supposed to use it. Is it correct? Like, he had his finger on the trigger. There was a number of things that took place in terms of the discharge of the weapon that were violative of departmental policy, correct?
That's correct. That's the allegation.
Okay. And in doing so, he then struck Officer Lego in the back, correct?
Yes, Your Honor.
So I guess the question I would have here in this situation is applying the standard that the court is in fact applying. If you have a highly trained task force, the way you have here, if you have departmental policies that are supposed to be adhered to and followed as they're supposed to be here, especially with people who are extra trained, is it not foreseeable? I mean, do you feel that it is foreseeable for Officer Lego to have to anticipate that he's going to be shot in the back by a fellow officer who is supposed to be conducting himself at the same level of training and expertise as is required for this task force. Is it your position that that in fact would be foreseeable for an officer like Officer Lego, who is in formation, who is commanding the formation, to be shot in the back? I mean, when we apply the statute and we look at the statute, is that something that is foreseeable for police officers to have to adhere to?
It is, Your Honor. And if you look at the policies that he's alleged to have violated, first of all, that he improperly inserted himself into the stack formation, that he improperly failed to maintain body contact with the officer in front of him, that he failed to maintain appropriate muzzle discipline and keep his firearm pointed in a safe direction, that he failed to keep his finger off the trigger. All of those policies, the goal that's in mind is to prevent one officer from shooting another in the back. That's why they have these stack formations, to try to prevent one from shooting another in the back. That's why you maintain body contact. That's why you keep your muzzle pointed in a safe direction. So those policies, the fact that we have them, recognizes that there's an inherent risk that one officer could shoot another in the back. And I think that there is an inherent risk as well that under the highest stakes, highest pressure situation, that a police officer faced with real life decisions being made in a split second about literally life and death, that someone could make a mistake under those circumstances.
Do you have a textual basis for your argument? Essentially, as I understand it, you could concede gross negligence, and you say you still win, right?
That's correct, Justice
Why?
Chief Justice. Because I believe that it's a normal, inherent, and foreseeable risk of the police
It's not-
profession.
Well, that's your belief. You have a textual basis for your argument?
For my argument that gross negligence is a normal, inherent, foreseeable risk.
Can I check? So, I mean, I want to get out of the weeds of like what happened in this particular case. I know you guys care about a lot, although I want to just figure out what the statute means for the rest of the cases that'll come next. And it's clear that the statute treats government defendants different from private defendants, right? The text of the statute with respect to government defendants is different than with respect to private defendants. And I think supports your argument that sometimes even gross negligence might be foreseeable and normal and inherent in police work, right? That could be why the statute's different. It seems to me even intentional conduct sometimes might be foreseeable, inherent, and normal in police work. So the chief and I are partners. Starsky and Hutch, I'm Hutch. Just
Thank
for the
you.
record.
I'm definitely shooting you. Oops.
And we are on a coffee break, and I make a very funny joke that he doesn't find funny, and he shoots me. That's not foreseeable or normal or inherent, and I think he shouldn't get immunity for shooting me on coffee break at my funny joke. I also think he could be grossly negligent, think my joke is not funny, and wave his gun at me, and, just not understand that the safety was off and shoot me, and that gross negligence conduct would not have been foreseeable or inherent or normal. On the other hand, in the kind of situation we have here, and without figuring out exactly, I don't think we have to figure that out right this second, but in street level, stressful, apprehending suspects kind of situations, sometimes grossly negligent conduct could be foreseeable. Sometimes even intentional conduct might be, right? For example, if, the chief is dressed as a suspect because he's undercover and I blow it and I intentionally shoot him because I think he's firing at me and he's actually a suspect, I intentionally shot him. And it may well be that it's foreseeable and normal and inherent in our work. On the other hand, if I shoot him because I'm like, oh great, I have cover and I've always wanted to kill him,
Yes, we
and
know.
and we're in, and I finally have my chance, and I make the mistake of telling Justice Larson that, so there's that allegation in the complaint, then it's not foreseeable. So it sort of seems to me like the legislature decided that police work is different than, and that we should have a rule that just asks whether what happened here was foreseeable. And in your view, this is one of those cases where it is, even if maybe it is grossly negligent. Does that make sense?
I think it's a fair statement of my position. I think the statute has to be doing something in the broader scheme of governmental immunity. If it's only covering conduct that's negligent, immunity from that sort of conduct, if it's taken in the course of employment and furtherance of a governmental function, is already covered by 691.1407 subsection 2, the Governmental Tort Liability Act.
Right.
So it has to be doing something more than that. And as it pertains to intentional conduct, I think that you're right. I think that the questions become a lot tougher when we're looking at intentional conduct. But then I think we also have to look at it, again, in the broader context of governmental immunity.
But do you agree with me that some gross negligent conduct is foreseeable, normal, and inherent, or normal, inherent, and foreseeable, and some is not in police work? That the coffee break, waving the gun, and shooting me, probably not normal, inherent, and foreseeable?
I would agree that not all risks are normal, inherent, and foreseeable
Even
risks
in police work, right?
of the police profession.
Right.
So you can,
I'm sorry, do you think that turns on the level of culpability? So is there, I think what Justice McCormick is trying to do is divorce the idea of normal, inherent, and foreseeable from the level of culpability, negligence, recklessness, gross negligence, intentional. If we were to go that way, would that satisfy you? Do you think that's the appropriate read of the statute?
If you gave the statute a broader reading than what I'm proposing, if you said that even intentional, if you said that all shootings are normal, inherent, and foreseeable.
No.
I didn't say that.
Some might be, and
Not
some might
Starsky.
not be. So, and Justice McCormick's hypothetical, some intentional shootings, intentional as in volitional, right, are not normal, inherent, and foreseeable. The one where she takes the Chief Justice out into the woods on the ruse that they're going to look for some hidden evidence, but really what she wanted to do was get him alone and have cover so she could kill him.
that's why this is Kevlar.
That is not normal, inherent, and foreseeable. But on her hypothetical, if he is an undercover officer and she is not previously acquainted with him, and she is an officer wearing a uniform, and she comes upon what seems to be a gang situation, and she thinks that he is a suspect and she has cause otherwise, and she shoots him, it's intentionally, volitionally, that might be normal, inherent, and foreseeable.
I think the mistaking identity question would be a grossly negligent act. It's a mistaken judgment. It's a mistake. It could be a gross mistake. It's failing to act in a reasonably prudent way. But to answer your direct question, I think that in the realm of possibility, there could be a situation where an intentional tort by a police officer against another police officer could be an inherent, foreseeable, and normal risk of the police profession. I think that an interesting problem could arise if that's true, because then if a plaintiff pleads an intentional tort against a police officer, and the plaintiff is a police officer, and 2966 says you're entitled to immunity because it was a normal, inherent, foreseeable risk of the police profession, there could be a situation where if you ran it through the test of Odom versus Wayne County, the intentional tort test for all other governmental employees, that you could come to the conclusion that they were not entitled to governmental immunity. So I think in the broader context of governmental immunity, it makes sense to say that 2966 does not deal with intentional and willful conduct.
Does what?
That 2966 was not written with willful and wanton or intentional conduct in mind. I think generally we don't expect police officers to injure each other or firefighters to injure each other in a willful and wanton way.
But 67 lists willful, wanton, intentional, gross negligence, and 66 lists none of the above. So, but you think we should read willful and wanton into it and intentional but not gross negligence? I don't know how to.
I think you could give it a broader reading.
Just a moment. I think this is a very important part of your argument. You better understand what you are arguing. 2967, which concerns the ability of firefighters seeking recovery from injury from the public lists all of these states of mind.
It does.
The prior section, 2966, has none of these. Is that, in your view, how should the court construe 66 in light of 67? You think that we can incorporate some but not all of the elements from 2967 into 66?
No, Your Honor. I think 2967 says that unless otherwise provided, and it also says that it shouldn't be used to construe any other right, remedy, liability, or immunity. And 29.
But there's something at least contextually relevant, is there not, in that there are two related statutes, one of which lists a lot of states of mind and one that doesn't. What significance should we accord to that? You say, well, I would take out intentional and willful and I'd import them into 66. That's what you just said. Why not gross negligence?
I'm not advocating for a bright line rule. I can see that there may be situations where there could be a police officer who injures another police officer out of intentional, willful, wanton conduct that could be a normal, inherent, foreseeable risk of the police.
Doesn't it seem that these two statutes are not only, as the Chief Justice suggests, in pari materia with each other, but that they stand in a hierarchical relationship with each other? In other words, 2966 affords greater protections than 2967 does in some respect. And the question is, what is that greater protection? Is that greater protection simply that all exercises of gross negligence are immunized? I'm not sure that's right. Does it, on the other hand, grant some additional protections for intentional actions? I'm not sure that's right either, but I'm not quite, I guess I'm in agreement with the Chief Justice that these do need to be looked at in pari materia and in some kind of hierarchical relationship with one another.
And so far, you don't have an answer.
I agree. These are tough questions when we're talking about.
It's nice if
intentional.
you have actually come to us with an answer.
I don't think that, generally speaking, we expect police officers to injure each other willfully, wantonly, intentionally.
I think that's evident, self-evident. The legislature has in three different statutes talked about general governmental immunity, and then this specialized and I think different and higher level of immunity given to police officers and firefighters. You acknowledge that.
I agree, and maybe I can answer.
But you're not helping us figure out what's within the ambit of 2966, especially in comparison. You made one reference to the generic governmental immunity, saying that the firefighter rule obviously gives some more protection to firefighters, but then you don't help us understand what's within the ambit of 66.
Counsel, you related or referred to this section that says this section shall not be construed to affect the right, remedy, procedure, or limitation of action that is otherwise provided by statute or common law in 2967. Can you expound on that point? Is it your position that perhaps 2966 and 2967 are not in some type of hierarchical relationship to one another?
I think 2966 is, I think under its plain language, I think that it is a broader grant of immunity, because it says a police officer
Well, that's a
is
slightly
immune from all tort liability.
It's a slightly different point. I'm just trying to get you to address whether the two are disconnected from one another or not, or should be read together, as some of the question suggests. If we're just focusing on 2966, you said a moment ago there's no bright line test. Does that mean that the foreseeability, whether it's a normal, inherent, foreseeable risk, then becomes a jury question?
No, I don't think so. I think it's a legal question of governmental immunity.
And how does a judge know if there's no bright line test,
Well,
how to decide the outcome? Is it just what the judge feels?
Haven't you transformed this into a fact question for a jury now?
That's not my goal. I think this is
I'm struggling to understand what your position is.
I think
now.
that this case is an easy case. I think that this case, as it relates to Trooper Liss's conduct, I think that his
I'm struggling to
accidental,
figure out how to articulate, and I think we all are, what the scope of 2966 is. What kind of conduct does it encompass? And now I think we're now trying to figure out, okay, well, who gets to decide it? If the issue is the normal, inherent, and foreseeable, I mean, usually those are words that we associate with jury determinations, fact finder determinations.
it seems to me that in the context of governmental immunity, it's usually a question of law for the court to decide. Accepting, in this case, the complaint allegations as true, or at a later stage, the undisputed facts. Applying ordinary definitions of normal, inherent, and foreseeable. So here we would look at whether.
So you don't think that we could have, judges could have a difference of opinion about whether a particular act was a normal, inherent, foreseeable risk of the job?
I think if they apply ordinary definitions, no, that there are certain risks that are ordinary, that are normal, inherent, and foreseeable, and those that are not.
I thought Justice McCormick gave you a wide range of different factual patterns that seem quite different. The intentional shooting of another officer who looks like a suspect, who's undercover.
I think under that situation, that's not an inherent risk of the police profession any more than it's an inherent risk.
It is if you're working undercover, is it not? I
Being
mean,
shot out of animus, Your Honor.
But
No,
why,
no.
why is it animus if it's intentional?
Yeah,
I mean,
I had
in
no
the-
animus. I was just trying to do my job when I shot him. I'm sorry.
I know, just like always.
I think that would be a negligent act.
But that's
Failure to act in
that's no more intentional than what we have in this case is intentional. In this case, there was an intentional shooting. Obviously, the circumstances were not fully understood by the defendant, but there's intentionality in this case, and there's intentionality in Justice McCormick's example.
They're both-
But neither are the kinds of intentionality, it seems to me, that distinguish them from gross negligence, are they?
They don't, under those circumstances, they don't intend that result. They don't intend that the other officer be harmed. They intend that someone else be harmed. It's a mistake in judgment.
It's an accident.
Correct. I see that my time is up. If I can answer any more
If you want to reserve time, now's the time.
I would. Thank you.
Good morning. Pardon me. I'm Michael Stefani, appearing on behalf of the plaintiff, Michael Lago. First of all, I have an answer to your question about how 66 relates to 67. But before I get to that, I want to address something that is more in my client's interest as far as this case goes. Because in my opinion, this is not a close case. The defendant agrees in his brief that gross negligence is not normal, inherent, and foreseeable. But willful, wanton, and intentional conduct is normal, inherent. I'm sorry, I got just the opposite. That gross negligence is not gross negligence is normal, wanton, and foreseeable. Normal, inherent, and foreseeable, but willful, wanton, and intentional conduct is not. In fact, he says that the general rule should be that gross negligence by another governmental actor is normal, intentional, normal, inherent, and foreseeable risk that any police officer has to live with. What he overlooks is that we have alleged wanton reckless and wanton conduct in our complaint. Paragraph 30 and 31 of our complaint specifically allege willful and wanton conduct. So it seems to me that by the defendant's own admission or claim, we have alleged wanton conduct, and therefore that is not normal, inherent, and foreseeable, and therefore the defendant is not entitled to immunity. Having said that, I do not agree with the defendant that gross negligence is not, or I should say is, normal, inherent, and foreseeable. I don't think gross negligence is any different than willful and wanton in one sense, and that is that unlike ordinary negligence, which can simply arrive from a little carelessness, willful, wanton, intentional, and grossly negligent conduct requires an element of a mental state. The very definition in 2967 defines gross negligence. It specifically has a definition of gross negligence, and that is conduct that it's so careless that it implies a deliberate disregard for the possibility that it may injure another person. Innocent mistakes are one thing, but risks that arise from gross negligence, willful and wanton conduct, require a certain mental, either an intentional, intending the results, or if not intending the results, at least disregarding the consequence that could result from the conduct. That's the very definition of gross negligence and willful and wanton conduct. The words disregarding the consequences and substantial lack of concern, these imply a mental state. And therefore, it is our belief that how 66 differs from 67
You're saying they're the same.
Pardon me?
You're saying the same mental state. There's
Yes.
there's no mental state referenced in 66.
That's
There
correct.
are 5 mental states: grossly negligent, wanton, willful, intentional, and conduct that results in a conviction. Those are all aspects of a mental state that are found only in 67. Is that correct?
That is correct.
So
And
if I understood you correctly, we should read the prior section, 2966, as having imported the status of mind that are found in 67, but not in 66.
that is correct.
Why?
Now,
Why would we read a provision proceeding that has none of those provisions as incorporating those that have the following provision that has them? Why would we do that?
because I believe 67, which has these, the requirement of gross negligence, willful and wanton, etc., I believe that it is consistent with 66 and 67 are to be read together, and I think that
Then why are they written separately? Why did the legislature, why is there 66 and 67? I thought it was because they wanted us to think differently about government defendants and private defendants and give us some guidance about how to think differently about them. That we haven't figured out what it means, but but that we're supposed to be thinking somewhat differently.
Well, even if you're supposed to be thinking somewhat differently, it's still it's, what you will focus on is the mindset of the individual. In other words, perhaps, I don't think this is the case. In my belief, I believe that 67 says that conduct which is normal, inherent, and foreseeable, when it results from a risk created by simple negligence.
Well, wait a minute. If that were true, there would be no need at all for 2966 because the generic tort immunity statute provides for immunity except for gross negligence. Does it not?
Yes, that's
Okay,
correct.
so if we have the generic tort liability act that creates immunity for all but gross conduct, what office is being, or work is being performed by 2966? If you say they're the same, as I understand your argument, gross negligence is excluded from 2966, and it's excluded from the generic statute as well. So
Yeah.
what additional work did the legislature intend to do when it abolished and codified the firefighter rule?
Because I believe that there are degrees of gross negligence, and what 67 does is.
No, I'm asking about 2966. 2966 is the firefighter rule of immunity.
I understand, Your Honor.
Well, then you were answering as to 2967.
Well, maybe I phrased it improperly, but 2966, certain gross negligence, depending on the mental state or the state of mind, how bad it is, in other words, would not be considered
There are degrees
normal.
of gross negligence?
Pardon me?
You're saying there are degrees of gross negligence?
I'm sorry, I didn't hear you.
Degrees of gross negligence?
Yes, I think there are degrees of
Gross
gross
and super
negligence,
gross.
and I think this one,
I think I get it, yeah.
yeah, I think this case, that's why I say this case is not a close one. This case is could be a textbook example of how a police officer should not act, especially a highly trained police officer, a SWAT officer.
Well, he wouldn't need immunity if he'd acted properly. Everyone's conceding
I
that he
agree.
engaged in at least negligence, probably gross negligence, maybe gross negligence plus, if there's such a concept.
And
it's
one-
only because of that he requires some kind of immunity.
That, I understand that, but this conduct is so far afield that
Why is
what-
it so far afield?
why is it so far afield? Because,
He violated the policies, right? Wasn't in the right formation, or,
well, first of all, we haven't had discovery yet, and
well, but let's assume all your allegations are true. Tell
I
me
know, but
what are the worst ones?
there are statements being made that, by brother counsel, the defense, that aren't in my allegations.
And now it's your chance.
Right,
So
we
tell
wanna
us the worst ones. What are the worst things that you allege happened?
Number one, he was in a different, across the street in a different shopping center, and he was watching what was going on in the shopping center across the street. That was his assignment. The action took place in the shopping center across the street. He left his position, drove in, instead of staying in the car, which he normally would have been his assignment, because the other officers had already deployed around the building. He left his position without telling anyone and inserted himself behind Officer Lego without properly telling Lego he's behind him, without making contact with Lego. He then had his finger inside the trigger guard on the trigger, and Justice Viviano, you made a comment when brother counsel was at this lectern that he he had his, something to the effect that he intentionally, I think you used the word intent, he intentionally shot. That is not in evidence. The gun was not pointed at the bad guy, if you will. The gun was pointed at the back of Officer Lego. The evidence will show that if he hadn't, that he probably didn't intentionally squeeze the trigger. He was surprised when he heard Officer Lego discharge his weapon, pow, pow, and he lurched, which is fairly common. That's why it's a basic rule. You keep your finger off the trigger until you acquire a target and you're ready to shoot. It happens. People tense and they squeeze the trigger and the gun goes off.
But if it happens, isn't it foreseeable?
No, it's not. And if I may,
You said it was a fairly common reaction. I guess I reiterate what Justice Viviano just said.
it's a fairly common reaction to lurch when you're surprised, but it's not fairly common for one officer, especially a SWAT-trained officer, to have his finger on the trigger of a gun.
That's just reiterating that he was probably at least grossly negligent here.
Yeah, I agree. I think it was worse than that. I think it was wanton in the fact that he was so anxious to get in on the action. Here's a guy across the street.
You think he willfully shot his fellow officer?
Absolutely not. I didn't mean that.
Well, using the definition.
Wanton is different.
He was indifferent to shooting his fellow officer.
He was so anxious to get in on the action.
But that's the definition you want to use doesn't read that way.
Pardon me, sir? Yes, he was indifferent to the consequences, not indifferent to squeezing the. Absolutely, he didn't want to shoot Officer Lego, but he was indifferent when he left his position, inserted himself in a line. You got three guys lined up. They're trained together, that know how the SWAT procedure goes, and he
I don't think
squeezes in
anybody's
there.
challenging your accusation or claim that he violated policy. That's not at issue. The question is whether that conduct is foreseeable and inherent and normal.
And that is my point when I'm talking about degrees of gross negligence. If there's a difference between 66 and 67, I personally believe that the way to read 67 is, if it's grossly negligent, it is not foreseeable. The fact that it is unnecessary because of the other immunity statute, is an anomaly. This wouldn't be the first piece of legislation that wasn't completely thought out.
Counsel, can I ask if you're just subtly transforming the statute? Several times you've referred to normal, inherent, and foreseeable conduct. It's normal, inherent, and foreseeable risks.
Correct.
When you talk about conduct, isn't there a tendency to focus on the shooting as opposed to what risks points you in the direction of considering, which is the injuries suffered? I mean,
I understand the question, but I
is it a
think
normal,
I disagree
foreseeable-
with that. I do not think that.
Can I just finish, please?
Oh, I'm sorry.
Is it a normal, inherent, and foreseeable risk that somebody will suffer injuries as a result of the misconduct or grossly negligent conduct of a fellow officer? It really forces you to look at the results as much as what actually transpired on the part of the wrongdoing officer.
Well, I understand your position, and you may be correct, but that is not the way I see it. I see it as that this legislation is focusing on not on the injury, and not on the mechanism of the injury. I mean, when I say the injury, okay, you got a bullet wound. The mechanism could be or it could be a broken leg, a broken back. The mechanism is whether it was fired by a gun, or a fireman tripped, there was a hole or a weak spot in the attic, and he trips and he ends up falling through the floor. Those are the mechanism of the injury. It's my belief that this statute focuses on the conduct that gives rise to the risk. And if the conduct is so outlandish, then it cannot be foreseeable. I mean, think about what normal, inherent, and foreseeable mean. Those are not, those are words that have a common meaning that we all understand.
So, counsel, where do you get that meaning? I mean, maybe it comes from our prior case law. So we have prior case law under the common law rule that interprets normal, inherent, and foreseeable. And I'm wondering whether you want to carry those over into this statute and whether you think that's tenable in light of the fact that the statute purports to abrogate the common law rule.
I believe, and I may be wrong, but I believe that prior case law that deals with normal, inherent, and foreseeable, all of those cases dealt with traffic matters. And traffic matters are quite a bit different. I mean, it is normal, inherent, and foreseeable that an officer, whether he's directing traffic at an accident scene or he's stopping a vehicle for a violation, it is foreseeable that he or she can be struck by a car. I mean, I used to be the police chief in Lake Angeles. We had one guy that on 2 different occasions, he's arresting a drunk driver and another drunk comes along and hits him. The same guy, twice. But so that prior case law dealt with, as I understand it, automobile cases. This is a bit different. And I would suggest that normal, inherent, and foreseeable, their definitions are well known. I would also suggest that there is Justice Jensen wrote in her opinion, I also conclude that being shot by a fellow police officer while engaging in an active shooter is one of the normal, inherent, and foreseeable risks that a police officer's profession should expect. When I read that, as a former FBI agent and a former Detroit police officer, I was shocked to read that. If it's normal, inherent, and foreseeable for one police officer to shoot another police officer, then you're going to have far, far fewer police officers, young men and women, become police officers. That is absolutely ridiculous. They train to be careful. That's the whole point of keeping your finger off the trigger.
Sir?
Yes.
I think that's what the legislature was getting at. The officers trained to do their jobs perfectly, but they're human and they fail. And it strikes me that our obligation is to give some meaning to what the words the legislature used. And one of the things that seems interesting to me is that in 2 of the 3 immunity statutes that involve arguably cover firefighters and police officers, is that 2 of them, the generic Tort Liability Immunity Act and 2967, have specific references to the states of mind which are excluded from immunity. And the thing that's singularizing about 2966 is there is no such exclusion, no state of mind that is excluded by the text of that statute. And so I'm asking you, what meaning should I give the fact that the legislature has chosen in 3 different places to have states of mind count for determining whether immunity occurs, and in 1 where there is no state of mind stated at all?
Well, as I've said, I believe that there may be differences in degree, but I believe gross negligence, willful, wanton, intentional conduct takes it outside of normal and foreseeable. However, if I'm wrong on that, then the fallback position is that it's going to be an issue that can't be decided without discovery. It is absolutely, it's really kind of silly to think that just anybody can determine what's normal and foreseeable and inherent in a police officer. I mean, police officers have talked to me about that Court of Appeals case, and they're just shocked. They said in their whole lives, 20, 30 years of experience, it never did they anticipate or foresee being shot by another officer. It's, and Brother Counsel says the reason that 2966 exists, because we don't want officers to worry about being sued by their fellow officer when they go into one of these split-second decision, dangerous situations. Well, what about the guy that, what about worrying about getting shot? We don't want the officer to worry about being sued, but it's okay for the officer to worry about getting shot.
Counsel, let me ask you this question. I want to go back to Justice McCormick's suggestion to appellants, and that is that we divorce the mental states from, what's our phrase of art, normal, inherent, and foreseeable. So the statute says normal, inherent, and foreseeable, and then it also includes mental states in 2967. So maybe those are two separate things, and the only question, when there's a question of governmental immunity, is whether it's normal, inherent, and foreseeable. Do you need to wrap this up in this question of mental state?
No, I did that based on one of the questions the court suggested that we address in our briefs. Am I committed to it? No. What I'm committed to is that if this particular case, immunity is granted, then I think, you know, it's so crazy.
So you think
maybe
on these facts, your position is it is not normal, inherent, and foreseeable?
Absolutely not. Now,
but that doesn't turn on whether the conduct is grossly negligent, wanton.
it turns in on how bad the facts are. Now, whether you call it grossly negligence, wanton, or you call it supersized gross negligence, I don't know. But the point is, it's a factual issue, and watching TV, watching police on TV or in the movies does not qualify the average person to determine what is normal, foreseeable, and inherent in a police job. It's got to be done after discovery, when there's been testimony. We've got evidence just sitting on my desk right there that needs to be brought to the attention. And so if it doesn't turn on intent or state of mind, then it's simply a case-by-case factual examination that you, after discovery is completed, and you've had the benefit of expert testimony.
So all these cases go to the jury?
No, not to the jury. Oh, no,
All
no,
these
no.
cases at least survive summary disposition?
No, I'm not saying that at all. I'm saying that
What is your position
the
then?
judge, it's still a legal question.
Okay.
But the judge, in any legal question, not in any, but in many legal questions, there are preliminary factual findings that have to be made. They're made by the judge. And then based on those factual findings, the judge makes a legal conclusion. But he can't do it, or she can't do it, without the benefit of evidence. He can't just simply, and the trial judge was right here. He said it's a factual question. He didn't mean it's going to go to the jury. He meant, let's get some facts. Let's get some expert testimony. Defendants imply that SWAT officers, it's more dangerous for SWAT people because they're confronting dangerous situations. In fact, it's just the opposite. SWAT officers are trained. There are far fewer injuries among SWAT officers. You know what made this an emergency life or death split-second decision, as defendants say? What made it that is this officer, Liss's, disregarding safety rules. running in and putting himself in a stacking formation without making contact, not letting the guy know it began, putting his finger on the trigger, all those things. This was not an emergency life or death situation before he made it emergency. These officers were trained, well-trained, they knew what they were doing. It never dawned on them they were going to be shot by one of their fellow officers.
Could I just ask a procedural question? You said that the judge denied the motion, but that didn't make it a case therefore amenable to a jury determination. Is that what you said?
Well, what I said is, my understanding is that the judge said it's a factual question.
Usually when that question is determined in that way, the case goes to
Not
the
when
jury.
it's a preliminary factual
So
issue.
procedurally, what is the posture of this case, assuming that the trial judges?
We go forward with
determine-
discovery. Based on that discovery, they can bring another motion or they can renew their motion. Then the judge, based on the discovery and the facts, then he will make a determination based on the law. I mean, as I understand it, it's the judge, whether or not immunity applies is a legal question. But it's a legal question that depends on certain preliminary facts. And the judge makes that determination.
So the next step in this, if the trial judge's determination prevails, what happens?
Excuse me, we go back and we have discovery.
And then what happens?
And then if they renew their motion for summary disposition, then the trial judge, based on those depositions, that testimony, those exhibits, the autopsy, the medical report, he then comes to his decision as to whether or not immunity applies. Now, he's going to need some guidance, in my opinion, from this court, because presently there is no guidance. You look out there and say, what does ordinary, normal, inherent, and foreseeable mean? And there isn't any guidance except where it's a traffic matter. Just looking at the words, and I have the definition here from Black's Law Dictionary, but I won't bore you with each one. Normal, inherent, and foreseeable, they're not that obtuse. Normal means it happens frequently, it's regular, it's expected. Foreseeable means that it's predictable. But, when you start hypothesizing really strange factual developments and suggesting they're normal, I respectfully request that the court affirm the lower court. I request that the lower court rule that risks brought about by gross negligence, willful wanton conduct, or intentional are not normal, inherent, and foreseeable for purposes of 2966. And I also request that the court affirm the ruling of the trial judge and the Court of Appeals.
Thank you.
Thank you for your time.
Thank you. Just 2 points. One is this idea that they've alleged willful and wanton conduct just isn't true. They haven't alleged any facts demonstrating that Trooper Liss just didn't care. The facts that they've alleged demonstrate a negligence. And getting back to an earlier point, if this statute has to be doing one of two things as I see it. It's immunizing gross negligence beyond the GTLA, or it's immunizing all tort liability for police officers against police officers. And that comes from the structure of the statute and the general principles of immunity.
So counsel, I just really want to make sure I understand exactly what your position is. And that way I'm just doing this to really have a clear understanding. So in this circumstance, in terms of if you're a police officer like Officer Lego, who's on the job in a highly sophisticated situation in terms of being on the SWAT team, who's gone through intensive, exhaustive training, who is a true professional in his field, The question I have is it your contention, is it the state's contention that ultimately, if he is in this situation following his training, that a rogue situation like this, that Officer Lego should see this as the normal part of his position, normal and foreseeable element of his position? I just want to have a clear understanding of this position.
Our position is that a mistake, even a big mistake that could be grossly negligent, is a normal, inherent, foreseeable risk of the police profession.
Is there any situation that you would see that it wouldn't be?
Not on these facts, Your Honor.
So that's just what I want to make clear. So basically, the state is basically sending a message to police departments that, for all intents and purposes, that, if you have a situation where you have the most grossly negligent circumstance, that ultimately police officers should just see this and understand this and appreciate this, that this is the normal per functioning role of their job.
The statute has to be doing something. It has to be immunizing some conduct beyond negligence. Otherwise, it's surplusage under the GTLA. And I think it has to be immunizing grossly negligent conduct, a mistake made under the highest pressure.
Could it be boots and suspenders? I mean, ordinarily, we say, look, we believe that all statutes are meant to do something, right? And so this statute must be doing something different than the Government Tort Liability Act. But sometimes legislatures write surplusage. And sometimes they write surplusage in order to shore up the point. So couldn't it be the case that this overlaps with the Government Tort Liability Act?
I don't think so. I think that we have to give this a reading, providing some immunity beyond what the GTLA provides. Otherwise, the whole thing is just extra language that isn't doing anything. If it only provides immunity for negligent acts, that immunity is already provided by the GTLA. So then there's no reason to have 2966.
Okay, but it could provide immunity for negligent acts. Immunity for negligent acts could be provided in two places, in the GTLA and here. Yes?
I don't think so, Your Honor. I think that the GTLA provides immunity for negligent acts that are taken in the course of employment, scope of authority, and furtherance of governmental function. This is specifically related to the profession of police officers and firefighters.
Mm-hmm. Okay.
Thank you. Thank you, Mr. Chief Justice.
Case is submitted.